I think the most important change is in something that's called the Bankruptcy Threshold Adjustment and Technical Corrections Act. This is a short statute that makes some changes to the bankruptcy code. So in order to understand the significance in Subchapter 5 of this change, it's important to know what Subchapter 5 is all about. So the bankruptcy code is divided up into chapters. By the way, this is a federal statute. There's no such thing as a California bankruptcy. And one of those chapters is Chapter 11. And Chapter 11 is the most complicated chapter in the bankruptcy code. It was originally thought of as just for businesses to reorganize, although it has been expanded to allow individuals to do so. And it provides a somewhat cumbersome process. A couple of years ago, the subchapter of Chapter 11 was enacted. It's called Subchapter 5, and it's for small businesses. So there are some limitations. GM could not use Subchapter 5 if it wanted to do another bankruptcy under Chapter 11. The benefit to Subchapter 5 is it streamlines the process a great deal, and it removes some of the negatives in Chapter 11. So, for example, in Chapter 11, in order to get the plan confirmed, you have to have, in a way that can be made precise, the consent of the creditors. The creditors get to vote on the plan. They're broken up into classes, and each class votes, and you have to have at least one class voting in favor of the plan in order to get the plan confirmed. But in Subchapter 5, you can have what's called a non-consensual plan, meaning that nobody votes in favor of the plan. Well, if it satisfies certain requirements, you can still get the plan confirmed. So that's a benefit. Another benefit is when in a normal Chapter 11, you have the plan confirmed because you have one consenting class, but let's say you have some non-consenting classes. They just won't go along with the program. Well, you can still have the plan confirmed using a process called cram down. But what that does is it triggers something called the absolute priority rule. And what that means is all of the assets in the bankruptcy estate stay there, you don't get them, and they're no longer yours. So if, let's say, you have a business and you're a shareholder, your stock becomes worthless because the entire corpus of the business stays in the bankruptcy estate and it's used to pay creditors. And the only way you can get stuff back out is by doing something called adding new value, dumping money in and in essence buying back your shares. Or on an individual level, you lose your possessions and the only way you get them back is by buying them back from the bankruptcy estate. If you're an individual, you can keep what are called exempt assets, but the non-exempt assets you have to buy back. Well, Subchapter 5 does away with the absolute priority rule. Subchapter 5 allows you to have a non-consensual plan, so it's really, really attractive. But it's only available for small businesses. Now, what's a small business? Well, the Bankruptcy Code has a definition, and one of the key elements of that definition has to do with the size of the debt, the total amount of debt. And when Subchapter 5 was enacted, that amount was about $2.75 million, and that's aggregate secured and unsecured debt, non-contingent liquidated debt. Well, that sort of excludes businesses that we might think of as small businesses, but they have a little bit more than that in debt. So temporarily, when the pandemic started, Congress bumped that up to $2.7 or to $7.5 million. But that's sunsetted. So new development here is in this Bankruptcy Threshold Adjustment and Technical Corrections Act. And what it does is it bumps it back up to $7.5 million. So that means that a small business can be a business that has more than the $2.75 million in debt and still qualify for Subchapter 5 and get all those benefits of being in a Subchapter 5 as opposed to the more standard Chapter 11 case. A related thing has nothing to do with Chapter 11. It has to do with, well, I suppose tangentially it does. It has to do with Chapter 13. Now, Chapter 13 is not available for businesses. It's only available for individuals and legally married couples. And you can sort of think of it as Chapter 11 light. You still have a plan of reorganization where you're going to be paying creditors, but it's much, much streamlined, and the creditors don't get to vote on the plan. Well, for the longest time, there's been a problem with Chapter 13, and that is there was an eligibility requirement, and it was a two-pronged eligibility requirement. It looked at your total unsecured debt. Those are debts where there isn't something that can be repossessed if you don't make the payments, and your total secured debt. And there were two debt ceilings. And if you exceeded either debt ceiling, you were ineligible to do a Chapter 13. Well, the secured debt ceiling was low enough that here in Southern California, where some folks have pretty pricey real estate and they have large mortgages, or maybe they have mortgages on a couple of properties, they were out of Chapter 13. So now what this act does for Chapter 13 is it says we're not going to make a distinction between secured debts and unsecured debts. We're just going to lump them all together and say if you've got a total debt load that is less than $2.75 million and you're an individual or a legally married couple, then you can do a Chapter 13. You don't have to do a Chapter 11. So the connection to Chapter 11 is if a person is ineligible to do a Chapter 7, perhaps because the income is just way too high, and was unable to do a Chapter 13 because of the violation of either the secured or the unsecured debt ceiling, well, now, in that situation, we put that person into a Chapter 11 with all that complexity, and maybe the person couldn't qualify as a small business, so there was not going to be any Subchapter 5 relief, so you're going to be stuck in the middle of a very complicated bankruptcy case. Now, with this relaxation and increase of the debt ceiling, this $2.75 million is greater than the sum of the old secured and unsecured debt ceilings. Well, now you can do a Chapter 13, and it's much, much easier to do and much less expensive because it's not so complicated than a Chapter 11. Now, I will say, though, these are going to expire. Like all of us, I suppose. They are good for 2 years, and then we'll see what Congress does at the end of 2 years. One never knows. But anyway, the big change in Subchapter 5, or the big development, is the increase in the small business debt ceiling, and the connection is also to Chapter 13, where now people that otherwise might not have been able to do Chapter 13 can, because of the change in the debt ceilings.